Okay, perfect. So we passed the first tech hurdle, which is one of the topics of today. What I wanted to do before really going into medias res is to try to explain what UNCITRAL is doing and what UNCITRAL is. So UNCITRAL is an intergovernmental body established in 1966 to modernize, to uniformize and to harmonize international trade law. You might ask yourself the question, how can we have limited membership and aim for universal lawmaking? This is because we have 70 members in UNCITRAL, but we do invite all other United Nations member states. So we do send out 193 invitations to every working group session and to every commission session. The reasons for creating UNCITRAL, there are a number of political reasons. One being that a number of African states wanted to become or became independent and wanted to participate in lawmaking, that we were in the middle of the Cold War and there was a need to continue, especially after the Cuba crisis, there was a need to continue to discuss on issues, and there was the general understanding that the two blocs needed to agree to disagree and to continue negotiating, continue speaking. So UNCITRAL has been established against this background. There were a number of legal reasons, of course, and these are that if you face very different rules in very different states, you have huge transaction costs. If you want to do trade with a country that has a legal system you are not aware of, you are facing the need to get acquainted to that legal system. You need to find lawyers, you need to find out what the legal rules are, and that could be terribly complicated. So the idea of UNCITRAL is to overcome national law and try to create international law, which would be easily accessible for everyone, which would have drafted in the 6 UN languages, so is available in the 6 languages, and has been drafted by the member states of UNCITRAL who come from all the different geographical regions. So we make sure that everyone is properly represented, every region is properly represented, and we do invite all the other member states of the United Nations to really make sure that we have a law that fits into all different legal systems and that states could agree to. So I said 70 member states. Now this increased over time. These member states are elected for a period of 6 years. We do exchange every 3 years. We do exchange half of the commission, and you see here on the slides that we have always 16 states from Africa, 16 from the Asia Pacific region, 12 from Latin America, 10 from Eastern Europe, and 16 from Western Europe and others. So this is to make sure that we have at least a certain number of states from these regions to make sure that they are properly, that these regions are properly represented. We are currently in a transition phase because we had 60 member states till 21, and then we decided on an increase by 10. And because we have this exchange of half of the member states every 3 years, we have elected 5 of these new member states at the last election in 21, and will elect the other 5 in 1 year, so to again be able to exchange half of the commission every 3 years. And if you want to have if you have questions on this enlargement process, you have the person to ask on in our meeting, because Takashi was the leading person as a Japanese delegate, so he can answer every question you might have in that regard. As already said, we do invite all United Nations member states as well. So we do have all the observer states, and we also invite inter and non-governmental organizations to the session. The idea being to have the available knowledge in the room when we draft a text. So the organizations that are invited depend on the text we are discussing, and they need to be accredited, but then they are invited and they are participating in the discussions just as the states do. So the organization of the work it's a three-step procedure, if you so wish. So you have the Secretariat. This is where Takashi and I am working. And I see that my colleague who is also working in Working Group II, Gai, is also from the Secretariat and also in this call. So if you have further questions there, feel free. Then you have the working groups. We have 6 working groups, and these working groups are doing the technical work. And then we do have the commission. The commission is the highest body taking the political decisions and assigning the work to the working groups and adopting the texts that the working groups have been working on. One exception being conventions. Conventions have to be adopted by the General Assembly of the United Nations, but all the other texts that the working groups are producing are adopted by the Commission. And here you do see the current working groups we are having. So we do have Working Group 1 on micro, small, and medium-sized enterprises. This working group finalized its work at the last session. So the texts they were producing a guide to access to credit for MSMEs is to be adopted by the Commission, which is why Working Group 1 will be assigned a new topic in July. Working Group 2 is having, and this is what we are going to discuss today, is the Working Group on Dispute Settlement. Then we have Working Group 3, Investor-State Dispute Settlement Reform, which is the working group which has the broadest mandate, because the mandate relates to the reform of the whole ISDS system. So there we have a number of different reform elements, and the first reform elements are on the agenda of the Commission this year. Then we do have Working Group 4 working in the area of electronic commerce. We have Working Group 5 working on insolvency law, and then 6, which is a new working group, negotiable multimodal transport documents, because the working group just finalized its convention on the judicial sale of ships. So this is what I wanted to tell you at the outset before really discussing the topic of today, because I think it's important to understand how UNCITRAL works to really appreciate the text and to use them properly. Now coming to the mandate of current Working Group 2, you see it on the slides. We were asked to develop model clauses. So we do have a text named UNCITRAL arbitration rules. Attached to these UNCITRAL arbitration rules, we finalized the UNCITRAL expedited arbitration rules because the Commission saw the need for having a streamlined expedited process, and this is what we came up 2 years ago. The states saw the need to further work on the expeditious process, and this is why the Commission gave Working Group 2 the mandate to work on additional model provisions that would be based on the UNCITRAL expedited arbitration rules and the UNCITRAL arbitration rules, and would allow parties to have an even quicker procedure. We were also asked, because we are discussing these model clauses, especially for high-tech disputes, which are disputes that are normally very technical. So we were asked to also draft a clause on experts, on mutuals. We were asked to draft a clause on confidentiality. Confidentiality is neither regulated in the UNCITRAL arbitration rules nor in the expedited arbitration rules. We just have a rule on hearings and on the publication of awards, but that's it. And this is why the Commission saw the need to include, for us to develop a model clause on confidentiality, and the idea of the whole mandate being to tailor the proceedings and to further expedite the proceedings. We are also working not only on in the high-tech area, but also on adjudication. And we try to develop model clauses to have a three-step mandate, to have a quick expert determination followed by a highly expedited arbitration to make that expert determination enforceable, and then have a full-fledged arbitration at the very end of the process once that the project has been finalized. This is not part of the slides today because we are focusing on these highly expedited arbitration. So what the working group has in front of it is the model clause A, which is on highly expedited arbitration. Model clause B is this multi-tier dispute resolution / adjudication type of disputes. Then we have the experts, we have confidentiality. Here we have a model clause on confidentiality, but we are also drafting a text on inbound confidentiality that will not be a clause, a model clause that parties could agree on, but that will be a guidance text. And then we have also a guidance text on evidence in electronic form. So here you see the slide on the highly expedited arbitration rules, model clauses, sorry, with the key features being that we are proposing an even quicker appointment process by requiring the parties to already determine the appointing authority, or even agree already on the name of the arbitrators when concluding the contract. Then we have time periods that are considerably shortened for consultation, for making the award. The idea being to have a proceeding that will be terminated within 60 or 90 days. The expedited arbitration rules currently foresee that the making for the award is 6 months. These 6 months could be prolonged under certain circumstances to 9 months. And if need be, parties could even switch to the normal arbitration proceeding. All of this should not be possible for these model clauses. So parties would waive their rights to change the proceeding, so as to allow for very specific cases, allow parties to be sure that they have their decision within 60 or 90 days. This is still all in front of the working group. So what I'm referring to is what the working group is discussing. I cannot tell you whether this is really what we are, the result of our discussion, whether these will really remain the features of the clause, but this is what is currently discussed. We are also proposing a checklist so that based on the assumption that parties and the tribunal want to make the proceeding as efficient as possible, the checklist could guide them on what they could do to make sure that the process is going smoothly. here is the multi-tier dispute resolution clause. So we would have three tiers: specialist, enforcement of that assessment, and the arbitral review. I'm not going into detail here in view of our topic. Then we have experts. This is, we do have rules on experts in the UNCITRAL arbitration rules. The idea of the model clause is to create, or to allow the arbitral tribunal to appoint an assisting expert. So the assisting expert would be an expert that helps the tribunal understand what are the technical matters that are at stake. So it would be an expert that would not really follow the approach of the UNCITRAL arbitration rules, in that sense that he would not provide, or she would not provide, a report, but it's a person that remains at the disposal of the tribunal, so that the tribunal can quickly make sure that they understood properly the technical matters at stake. We will see where this discussion is leading us. It's of course a very difficult balance that we need to keep between the tribunal not delegating its decision-making power and only referring to the assisting expert to really understand the matters in case, and the fear of the expert becoming too important. So this is something we are currently discussing. Then we do have confidentiality, and as already said, we have two different sets. We have the model clauses for the, or we propose the model clause for the parties to include into their contract, and this is because we do not have such an all-encompassing rule, neither in the UNCITRAL arbitration rules nor in the expedited arbitration rules, which is why this has been suggested. The guidance document is for inbound confidentiality, so how to make sure that each party can preserve its trade secrets, its business secrets, and on the other hand, guarantee that due process is taken care of. That includes the possibility of the other party to assess what the elements of the other parties are, what they are raising, the issues they are raising. Again, a delicate balance to be taken care of. And then we have, and this is probably the most interesting issue for you, evidence in the electronic form. We do have rules on guidance, on evidence. We do have guidance on evidence, but we have nothing so far on evidence in electronic form. So this is for us quite new. We do have text on electronic commerce, so we can draw from that experience, but we didn't merge the knowledge we acquired in this working group 4 on electronic commerce. We didn't merge it yet with the arbitration world, and this is what we try to do in this guidance note. The problem of drafting this guidance is, of course, that we want to draft a note that would still be relevant in a number of years, and developments are so quick that we are facing the issue of how we could make sure that whatever we do today is still relevant tomorrow. The two points we want to discuss is the large quantity of electronic evidence, and we have these large quantities because we have technology at our disposal. And then the second big point is, of course, falsification of electronic evidence, which is maybe easier to falsify with the new and emerging technologies. So these are issues we are trying to discuss and to try to encapsulate in our guidance note. So where are we now? We have had our last session in February in New York. We were asked to revise the model clauses as you find them in our last paper. This is the usual type of work we are doing. It's kind of ping pong between the Secretariat and the working group. So now the ball is in our camp. We do have to revise the model clauses according to the guidance that the working group gave us. And what is interesting is that the working group asked us to conduct informal discussions with potential users and with experts. And that is what you do see on the slide. We had some kind of these informal discussions. We had a roundtable at the Vienna Arbitration Days. We had an informal webinar for Working Group II delegates, to which we invited experts and potential users. And then we had a questionnaire to collect feedback on the need of the work we are currently doing. So you can see in the slide that you can still participate in this survey. There has been no deadline. So whoever is wanting to contribute the experience, we are very happy to receive your view. The next session will be most probably will take place at the end of September. The date is still tentative because we need the Commission to decide on the date. The Commission is meeting from 3rd July till the 21st of July, and the dates will be decided on the 20th of July if everything goes according to plan. So after the 20th of July, we can tell you for sure what the dates for Working Group II for the next session will be. And this is what I wanted to give you as a kind of introduction. Takashi is now going to explain further the exploratory work that we do. This is a very usual procedure before the working group is assigned a mandate by the Commission. We are conducting exploratory work to make sure that what we do makes sense, and that the work we are conducting in the working groups is really based on a need that is existing, and that we are not working on areas that have no real relevance in the real world. Thank you very much.
Thank you, Judith. It looks like the working group too is quite busy with a lot of difficult topics to deal with at the moment. I was curious from the previous work of the working group too. I've seen that at the moment does discuss a possible definition of what represents a tech dispute. And the definition was rather broad. I'm wondering if this is something that the working group is still considering to have a definition there or not. Maybe you can give us some insights.
Yes. No, what we usually do from the beginning of our discussions, we are working on the basis of provisions. And there was a proposal for such a provision to try to define tech disputes, and the working group agreed very quickly that that would not be useful. The background being what we are trying to develop now are model clauses for parties to include into their contracts. So if the parties see the need to have these highly expedited arbitration, or to have a confidentiality rule, or to have experts, then they should take it. We don't need to define for the parties what they might wish to use or not. So this is why the question of definition has been dropped quickly.
It makes sense. I think it makes things a bit easier and a bit more streamlined, rather than trying to encompass everything in one definition. Thank you very much, Judith. We're going to move now to Takashi, who's going to give us an overview of the project that he's working on and he initiated on dispute resolution in the digital economy.
Right, thank you, Mihaela. Let me take a moment to put the slides on the screen. So here we go. I hope
Yes.
you see that. Great. Okay, so I am going to take a moment to discuss dispute resolution in the digital economy, which Judith has already clearly explained that it was exploratory work, and it is expected that this project will feed into Working Group II in the near future. So, well, having two offices on the screen, our personal relationship, mine and Judith and mine, would obviously be that my role would be to keep Judith busy after she efficiently completes her work on that is currently going on with regards to tech disputes and adjudication. So, and hopefully she would be happy with the work that would be coming up next. And so the project was launched by the Commission in 2021, and it conferred on the Secretariat the mandate to monitor the changing landscape of dispute resolution in the digital economy. And what we mean by monitoring the changing landscape is that we compile, analyze, and share relevant information. And as Judith clearly set out at the very outset about what UNCITRAL is a legislative body in the field of international trade law. So we do this exploratory work with a view to laying the groundwork for possible future work on updating UNCITRAL text or developing new ones if necessary. The focus of the project is twofold, one on the negative and one on the positive. On the negative side, disruptive aspects of digitalization and dispute resolution, especially those with respect to due process and fairness. And on the positive, enabling aspects of technology and impact on, especially on impact on cost and duration, which I will discuss further in my slides. So here are the questions that the project has been exploring so far. It lists 7 questions here, but I think it would be relevant to maybe perhaps touch on 3 that I might be looking into more detail as I proceed with the slides. The first 2 questions, as you see, what are the prevalent means of communication and arbitration, and which procedural steps remain paper-based? Is a very basic but important question that we've been asking ourselves for quite a while. Secondly, are electronic awards issued in practice? And do legal frameworks need to be adjusted so that they are more conducive to the issuance and enforcement of electronic awards? And I just want to skip to the penultimate question, where are we in terms of the use of AI, specifically AI-assisted decision-making? So you will see other important questions such as case management and also interim measures that have attracted interest in our discussions, but I would just like to focus on the 3 later on. So the slides that you see right now, it used to be upcoming activities, very broadly defined, but we're almost coming to the commission session in July this year. The commission session is just around the corner, so I just changed the subtitle of the slide to 2023 and beyond. Towards the commission session, we have been requested by the commission to report to the commission on the preliminary findings. So Judith and I have been working quite intensively to put together a draft, which will be issued very shortly. In doing so, as this is a UN activity, ensuring comprehensiveness is very important. So we've been conducting research, but also alongside organizing discussions to seek inputs from different parts of the world so that their perspectives are properly reflected. And because gender is as an agenda that is of high priority within the UN system, we are always looking into areas where we should further consider gender perspectives also with regards to this DRDE project. So, and beyond, after the session that is coming up next month, we will look further towards the future into the commission session coming up in another year in July 2024. Of course, this is subject to the commission's views that will be expressed during the commission session next month, but we anticipate that the commission will request that the Secretariat report further to the commission on progress achieved, including proposals, concrete proposals on legislative work on certain topics. And in doing so, we will continue and keep with our commitment in trying to ensure comprehensiveness and also to include gender perspectives. So what we have been doing so far, because as I mentioned that we try to ensure comprehensiveness of our work, we contemplated about how we do this and make this happen. We embarked on this initiative that we call the World Tour. We thought that a very straightforward way of seeking inputs from different parts of the world is just to go there. And we have been organizing discussions so far, and we will continue to do so. And you will see a list of discussions implemented so far, starting with Tokyo last December. We have held discussions in New York, Guatemala City, Paris, and also in Vienna. And to continue on with this endeavor, we will be organizing discussions in Abidjan, Cote d'Ivoire, 27th of July. This is still to be confirmed, but hopefully we get information made public in the very near future. And we are hoping also to organize discussion in MENA, Middle East and North Africa, Sub-Saharan Africa, and also in Oceania towards later this year. So let me just walk you through some of the topics that we have been discussing in the organized events. I have taken the discussions in Tokyo and also in the Latin American and Caribbean region, which was held in Guatemala City, because we have managed to secure time to discuss comprehensively pretty much all the topics that we had hoped to discuss. And the panels both consisted of 3 panels, one on use of technology in arbitration, a second on online mediation, and third on dispute resolution on online platforms. So on panel 1, which discussed use of technology in arbitration, the topics discussed were basically the 6 on the list: electronic communication and e-awards, case management, e-document production, new forms of presentation of submissions and evidence, online hearings, and AI and the decision making. And I will, as I gave a heads up earlier on, I will be talking more in detail, a deeper dive into the topics that are highlighted in yellow. So on electronic communication and e-awards, a very high level overview about what was discussed is that it was found that the predominant means of communication in arbitration was electronic and not paper-based. That is to say that email, file share, and case management platforms were frequently used, but the notice of arbitration and awards remained an exception. And especially on awards, it was said that some jurisdictions required paper-based awards to be paper-based as a matter of domestic law. And the reason being that awards were basically paper-based, reference was also made to the New York Convention in Article 4A, which made reference to the duly certified copy. So this is a slide, the slide that you see right now, the pie chart in color blue, gray, and orange. This is a result of a survey that was shared with us by Professor Maud Pierce of Ghent University. this was kindly introduced in one of the discussions we had in the world tour. And she has also kindly shared with me what this pie chart actually meant and what kind of explanation this pie chart should be accompanied with. So for the sake of accuracy, I would just like to share what I have been shared by Maud. So the survey was one that was conducted by the Center for the Future of Dispute Resolution at Ghent University, and it was addressed to arbitration institutions that were considered leading on a global or regional scale. 43 commercial arbitral institutions were reached out to with the survey, and 22 responded. And as you see in blue, 30% of the institutions responded that they still send awards exclusively on paper. And as you see in gray, 10 of the institutions responded that they had experience issuing electronic originals. And the majority you see in orange, 60% of the institutions, they responded that they had experience providing both paper and electronic versions. But of the 60%, 80% of the institutions indicated that these electronic versions consist of mostly simple scans of the wet ink originals. And while I am on this slide, it's not that I have a specific slide to share with you. I also wanted to talk about some of the findings of the world tour, which has enabled us to find out more about the rather exceptional practice concerning electronic awards. This is not part of the study that is on the screen, but based on our research in Panama, arbitral awards are made exclusively on paper in some cases, and those awards have subsequently been enforced by its courts. And what we have learned was that in Panama, the Panamanian Arbitration Center authenticated copies of awards with the electronic signature of the center, which was registered with the competent authorities. And also, another story that we heard from Rwanda was that in Rwanda, subject to the agreement of the parties, awards were made and communicated to the parties electronically. It has been raised to our attention that quite a few awards from the center in Rwanda have been issued electronically, and we are in the process of trying to find out more about the situation in Rwanda and more broadly in Africa. But I do nonetheless want to point out that we need to really keep in mind that these experience in certain jurisdictions regarding electronic awards, they are limited within their domestic context, and whether those electronic awards might work in the cross-border context, we still need to find that out. So on electronic awards, what needs to be done? The points made, the suggestions made in the course of the discussion was that current practice takes a better safe than sorry approach, so express rules were necessary for broader acceptance of electronic awards. But at the same time, the New York Convention was felt that it should remain as the foundation, but it could be possible that a complementary convention providing favorable treatment to digital awards may be contemplated. And another final point in this slide that you will see is that it does seem that it was suggested that this topic about electronic awards may involve a broader agenda on harmonizing digital-friendly enforcement proceeding in court practice. So I just wanted to touch briefly also on this topic of electronic document production. It does seem a topic relevant also in the context of AI, but still what I just wanted to quickly share with you was that regional perspectives were shared in the course of discussions. At the Tokyo Forum, reference was made to the increased use of sophisticated platforms for electronic document production. but at the same time, the need to address concerns on trustworthiness of the outcome and cost and applicable standards on privilege and cost confidentiality was also pointed out. So I just also wanted to add a small footnote that Japan is not necessarily not a common law country, but still because the discussions in Tokyo was the first of a series of discussions that we were hoping to hold. We invited a common law practitioner who we assumed to have extensive knowledge about document production. So this was pretty much the reason why there were in-depth observations about this subject in Tokyo. Whereas in the Latin American event we had, the discussions pointed out that such concerns regarding electronic document productions were quite unique to only two common law systems. And it was stressed that international arbitration did not have to follow e-discovery practice. So I think this gives a sense that maybe some topics may be very important and interesting for certain jurisdictions, whereas it might not be as much for others. So this was a learning experience. So we go now finally into the topic of AI. What was discussed regarding AI was that in practice, AI was used in electronic document production and also on the part of the parties regarding on outcome prediction and also to facilitate decision making. And so because the parties and councils were using AI, it was felt that to a certain extent that arbitrators and the judges, the decision makers, might be compelled to use AI at one point in time so that they are not under-equipped. But caution was also obviously raised against insufficient data and also quantitative assessment. But on this point of caution, it was also pointed out that efforts were being made by legal service providers to address insufficiency of data. So these were the points made with respect to AI. I think, and I'm sure that this feeling is felt by everyone, is that AI is a rapidly evolving area and that it would probably be quite premature to draw any conclusions as to what kind of standards or rules that we can actually put in place at this point in time. But UNCITRAL remains interested in and keen on following and closely monitoring this area of AI. So with this, I think I still have some topics about online mediation and also about online platforms, but I do think I've exhausted most of my time, and I think it might be a good timing for question and answer to have further discussions about the project and also about the topic that Judith discussed. So with this, I conclude my presentation, and back to you, Mihaela.
Thank you very much. I'm sure AI will gonna keep us busy for a couple of years now. We have a question in the chat, and this question is for Judith. The question comes from Michael. I'm not sure if Michael wants to ask his question, or should I? Okay, I will read the question then. Oh, we have him on camera. Please. You're on mute at the moment. Still on mute. We cannot hear you. Sorry, Michael, you're on mute.
Sorry, there we go.
Yes.
Thank you so much, Mihaela. Judith, yes, my question goes back to the point you made about the scope of work of Working Group 4 on electronic commerce not yet having been merged or integrated with the work of Working Group 2 and indeed some of the work in Working Group 3 on investor-state dispute settlement, particularly with regard to dispute avoidance, may also be relevant to Working Group 2. So given another thing that you touched on, namely that developments are now moving so quickly, how can this vital cross-referencing between working groups be promoted? Because it seems that there's an incredible amount of value in that cross-working group collaboration.
Yes, hello, Michael. Nice to see you.
Good to see you too, Judith.
A long time.
Thank you so much for your presentation.
Yes, that's a very good question. So what we try to do is to each working group tries to follow the work of all the other working groups, and very often we have the same delegates sitting in different working groups, so you have kind of synergy hereby. For working groups 3, we try to, especially in the area of dispute prevention, we are not there yet because we have no, we prepared a first draft of a guidance document that was seen as being too prescriptive. And the work of Working Group 4 or technology doesn't really, for the time being, is not really raised as something that is extremely key. It's more on the organization of how you do organize your state. If we talk about e-commerce or electronic text, we are always only talking on the legal aspects. So we will not, in the area of dispute prevention, for example, we will not be developing a scheme how to technically foster digitalization within the governments. This would be outside of our mandate. So we need to make sure that we keep the line of our mandate. And yeah, we try our very best to make it work. I know that's not very satisfying as an answer, but this is how it is. We have another working group where we have attempts now, and that is insolvency, to combine the thinking in the area of insolvency and dispute resolution, because there again you have a lot of issues that should be considered together, and this is what we try to do.
Thank you. Thank you.
We just have a question which arrived now from Andre. I'm not sure if he wants to address the question himself.
Yes, Mihaela, thanks very much. And thank you to both speakers for the exciting presentations. My question is a bit of a taking a sideways look at it. I wonder, UNCITRAL is typically kind of nation state based, as Judith explained in the beginning, body. But I was wondering if, since the technological innovation is taking place, a lot of it on the cutting edge within the corporations, within the companies, I was wondering if there is any attempt to involve them into discussion, or do you see any interest from companies like that? Thanks.
That's again a very good question. So I will go first, and then maybe Takashi would like to complement. So UNCITRAL is an intergovernmental body. What we try to do is we try to invite, or we are inviting NGOs and IGOs to our discussion to make sure that we have the knowledge in the room. So in the area of arbitration, for instance, we would of course invite PCA, we would of course invite ICC, and so on and so forth. We did not extend the invitation so far to companies. What we do in the exploratory work is that we try to speak with everyone, and we try to when we do a colloquium, we try to invite outsiders that are normally not part of these discussions. I'm not sure if we would like to invite them to our regular discussions. I'm not so sure that would probably require a decision by the Commission if they really would like to have private actors also be included in the formal discussions of what we do. So I'm not so sure what would be the response by the Commission to that. But when doing exploratory work, we try to gather the views of everyone. And the questionnaire that we put on the slide, for instance, is such an attempt to also request input by users if they want to be included into the discussion. So informally, yes. Formally, no.
No, I think, Judith, your response was super clear that I really don't have anything to add. But I think in the course of discussions that I had, I organized for the DRDE, we have invited general counsels, in-house counsels of companies as well. But this is precisely to hear what the actual needs are of the users. And yeah, and this is obviously done in an informal manner as compared to what we do in these formal working group or commission sessions. So yeah.
We have another question from Michael on new awards, electronic awards. Michael, you want to go ahead?
Thank you very much, Mihaela. And I'm sorry to be so interventionist, but what's been said has prompted a lot of questions. Takashi, when you were speaking, you spoke about the possibility of a complementary convention for e-awards. And my question really is this: if an e-awards convention simply says the same thing as the New York Convention, isn't it superfluous? And if it differs or differed from the New York Convention, isn't that an invitation for technical compare and contrast points to be taken by eager, some would say over-eager legal practitioners, perhaps like myself?
Thank you for your question, Michael. And I think on your first point about if it was the same as the New York Convention, it would be superfluous. Yes, I think it would be superfluous. It was the same. But so I think it would be important if this were to go forward. I mean, for the Secretariat, as probably you know, we don't take views or positions about what should be done by the Commission or the working group, but we are always in a position to assist. If this were to be taken forward, I think it would be, the main objective would be to put in place, or, well, if it were to take the form of a convention as suggested, it would be to have a legally binding framework that would oblige states to take a more digital friendly approach with respect to awards. So I think, although in abstract terms, I hope this response and answer to your questions. And on your second point, I was not so sure if I actually accurately captured what you actually meant, and if you can just
well, what I was concerned about is that if you have, for any lawyer, if you have two different texts, there is a great temptation to put text A next to text B and say, text B has a slight difference of wording. It must have had a meaning, and you start diving into trying to discern a difference in meaning when maybe there was no difference intended, and it becomes great for the lawyers, but not necessarily great for the parties.
Mm-hmm. Yes, and on that point, I think if I'm not mistaken, I think you're looking at the point where maybe an additional convention might narrow down the scope of the New York Convention is probably one possibility that could happen. Maybe I should not speak in my capacity with the Secretariat, but just express my personal thoughts listening to your question. And I do think that, yes, that could be a risk, but at the same time, I think UNCITRAL has been quite effective enough to send out messages as to how, not from the Secretariat's perspective, obviously, but how this should be understood within the international community in a healthy manner. So I think, of course, that the concern and issues need to be addressed, and adding another text may create those extra layers of issues. But I think the suggestion is based on the understanding that in this rapidly, increasingly digitalized world, that there's work to be done in that sphere. So yeah, thank you.
I think Andre has a follow-up, if you may.
Yes, thank you. Just on the same topic about the complementary convention, I just remember and I looked up, there was the UN Convention 2005 on the use of electronic communications in international contracts. So since 2005, there's been 18 accessions to the convention, which is fairly modest, I think, to for this period of time, almost 20 years. That convention applied to arbitration agreements, but not to arbitration awards. So something in that convention seems to have made it less popular, modestly popular, as these conventions go. So I wonder if you have considered, push for further adoption, or so that is kind of a convention that might resolve half of the issues, but not all of the issues.
Yes, thank you for raising that point. I think, yeah, as you said, I think it addresses half of the issue, especially on the electronic formation of arbitral agreements. But I think the suggestion is to take it further and to address the issue about the process further coming up later on about issuance of awards. And I think, yeah, perhaps it's probably understood that that part needs to be addressed separately outside of the convention that was put together by the electronic communication experts.
I know that we are past the allocated time, but if I might ask one question for you, Takashi, on the use of AI in the process of decision making. You said that you discussed this with the groups that you met, and I was curious to know whether there are some examples of issues or legal matters that are safe to delegate to the AI, and others that by no means should not be delegated for an AI to decide.
Yeah, thank you for the question, Mihaela. I have heard interesting discussions being made in the process of the organized discussions. And going first about the actual use cases, I think probably everyone has heard about the Colombian judge consulting AI on Colombian family law matters. And also another point that I can share with you is about the Chinese judiciary using AI to assist its provision of service. So I think those are the only two that we have identified so far, and not in international arbitration. And on your point about possible areas or where it could be delegated to AI, I think this will be on a very personal, based on a very personal experience, my personal experience as sitting as a judge. But I think we need to take it one at a time. And I would think that it would start with the most simple part, like drafting of the history of the procedure, where it could be extracted relatively simply from the record. And also this is not my personal idea, but I think what we've heard in the course of discussion was that maybe damages could be calculated. Calculation of damages could be dealt with by AI is another thing that as another idea that we have come across. And the flip side, of course, what should not be delegated to AI, my gut feeling is that in making decisions on, especially on those requirements such as negligence or legitimate expectation, or if you translate those kind of abstract requirements into the field of international arbitration, maybe in investor state, you have this requirement about fair and equitable treatment. Those kind of broad requirements, I believe that it requires a very complex and delicate analysis of facts and application to the requirements. So I think we're still not there yet, is the sense I get, and I'm not so sure if we will ever get to that point, considering that humans rely on humans to decide on a case and to have, to take ultimate responsibility for that. This is my response for the time being.
Thank you. Yes, I agree. We're maybe issues about good faith, which are again very difficult to delegate to NI. But it's good to know that we are not out of business, and there are a couple of things that we humans will have to handle in the future, and not to delegate everything to artificial intelligence. We are past by the hour, but I just wanted to thank everyone for your time and for the interesting discussion. And we're gonna make the recording available for later for you to check it or share it with your contacts. Have a lovely evening or rest of the day, depending on which side of the world you are. And thank you again, Takashi and Judith, for your help.
Thank you so much. A great pleasure, Mihaela.
Thank you very much for the invitation again, and hope that we continue our discussions.
Certainly so. Thank you.